next case we have on the docket is Rossi versus Rossi. And I believe we have counsel for the appellant, is that correct?
That's correct, Your Honor.
Okay, and we're not permitting argument from counsel for the appellee as nothing has been filed thus far, so you may proceed.
Good morning. May it please the court. My name is Joe T. Caruso. I'm representing the appellate in this matter, Celeste Rossi. Celeste and George Rossi were married for 44 years. They both started off being school teachers, and after 13 years, Mr. Rossi realized that they would never be wealthy if they both continued to be school teachers, so he became a real estate broker in Brevard County, and he just happened to become a broker at the time that the real estate boom hit Brevard County in the early 1980s, particularly with regard to commercial real estate. Mr. Rossi made a lot of money. At trial, he testified he couldn't believe how much money he was making, and although in the beginning he had IRAs and 401ks, he was under the opinion that you were never going to enhance your retirement if you didn't have a different type of investment. So he decided to invest in gold and silver bars and coins. And as he testified at trial, he would take a briefcase with 10,000 cash, sometimes 20,000 cash, sometimes 50,000 cash, and he would go to coin shows. And at these coin shows, he would buy silver bars, bullion, he would buy gold bars, or he would buy 1 ounce silver coins or 1 ounce gold coins, and he would take them home. Over the course of the years, while he was making all of this money and investing in coins and bullion, he had 4 safes in the house. He had one in the exercise room, one in the bedroom, he had one underneath the stairs in the hallway, and he had a safe that he had acquired when Barnett Bank closed in Cocoa that he called the Big Boy, 5 feet high, 5 feet wide, and 5 feet deep. He testified that over the course of the years, all of the acquisitions were in these 4 safes, and when they ran out of room, they put it in a hole up in the attic. All of the acquisition of these coins were from marital income, the money that he was making as a real estate broker while his wife was working as a school teacher for 44 years. So the issues at trial had to do with the equitable distribution of the coins and the bullion, which he testified was approximately $1.4 million. And he testified that the wife, or the evidence showed that the wife had retirement funds of about $500,000. So he had a total marital estate of $2 million. What happened during the course of the proceedings and before trial, since an inventory had never been made by Mr. Rossi, is we got an order for for an inventory of the coin collection and the bullion collection. The date of the inventory was rescheduled 3 times at Mr. Rossi's request for health reasons, for one reason or another. And the date that was finally agreed upon, he requested a 4th continuance of 3 days, which was granted. The person doing the inventory went to the house when the inventory date was finally scheduled, and he found out the whole house was in disarray. You know, the safes were all open. 2 of the safes were empty. The coin boxes that are hard plastic boxes that silver dollars, 25 silver dollars go in each, and 25 gold coins go in each, they were all empty. There was bags that were marked silver, $half, and they all had pennies in them. So Mr. Rossi's explanation is someone had come into the house and removed his entire $1,400,000 collection. Mr. Rossi was the only one in possession of the house from January 13th to 2013. He changed the locks when he came back home from rehab. He changed the code, security code, and Mrs. Rossi or no one else had any possessory rights or entered the house after that time. Mr. Rossi had no explanation for how it got removed, and didn't report it to the police, didn't report it to the insurance company, and he had a specific insurance policy on the coins. Didn't report it to them. Didn't report it to his wife that our retirement nest egg has been stolen and disappeared, and I don't know how it came about. At trial, the general magistrate that had this 4-day trial, which was unusual for a general magistrate to usually have short hearings, she specifically found in her recommended order that the husband's testimony was inconsistent and unbelievable. The husband's actions with regard to the missing coin collection lead the court to believe that he has or had control of the collection. The husband is the only person with the access and knowledge to have secreted or sold the collection.
Counsel, obviously, from the record, and we have received the record and gone through the record, there was obviously concern expressed by the magistrate as far as the handling of the coin collection. Our concern is there were clear rules pursuant to the family law rules as far as how to take exception with the magistrate's report, and those were not followed. Is that correct?
I think if you're talking about filing exceptions within 10 days...
Correct.
That is correct. But so, I believe...
So what we're focusing on now is there was a motion for rehearing that was filed prior to the party prior to Ms. Rossi choosing, or her counsel choosing, to file the exception to the report, correct?
That is correct. I filed a motion for rehearing, and the basis of that is the case law says that a trial judge has the authority and jurisdiction to alter and change any interlocutory order before a final judgment is entered.
But procedurally, since you have a case before a magistrate, isn't the proper first step to file an exception to the report? In my judgment, I don't think so. I think that you can file a motion for rehearing if there are obvious errors that are made by the trial court. I think that you could...
Filed within the 10 days?
Yes, the motion for rehearing was filed within the 10 days. There's no question about that. And then the magistrate's order, if you look at the order she entered, she was under the impression that I can't consider a motion for rehearing because she said the only way is by filing exceptions. By the time I got that order, the 10 days would run. I immediately filed exceptions on the same basis that were contained in the motion for rehearing. And originally, the magistrate said, I've got to have a transcript. I will consider, we will have a hearing on the exceptions, but I have to have a transcript, because I had filed a motion to waive that because the cost of the 4-day transcript was $3,000. And then after the transcript was filed, she entered a order without a hearing, which says, since the exceptions were filed late, I don't have to hear them, and I'm not going to hear them, and so the exceptions are denied. So I filed a motion for rehearing since she had made a final determination that she was not going to do it, and of course she denied that also on the basis that if the exceptions are not timely filed, I don't have to hear them, I'm not going to hear them, and in her final order, even though a judge, if no exceptions are filed, the case law says the trial judge is supposed to determine whether or not there's a legal or factual basis to support the decision. In this case, knowing that we had filed a motion for rehearing, knowing that we had filed exceptions, she still did not review in her final order, she did not review the transcripts to determine if there was any merits of any of the exceptions that we had made. And, I think that even the rule says that if timely exceptions are filed, the judge has to have a hearing. The rule doesn't say if the exceptions are not timely, the judge can't have a hearing or shouldn't consider the exceptions.
Is it in the judge's discretion at that point?
I think that certainly she could have, yes. I think it was discretionary at that point, but I believe that a trial judge sitting under these circumstances that knows that certain errors are alleged to simply say, I think it would be prudent on their part, and I think it would be fair to the parties to at least evaluate the exceptions by reading the trial transcript, which she did not do.
I just want to go back to the procedure. You received the report. The report says you have to file exceptions within 10 days. And you file a motion for rehearing. Do you believe the magistrate has jurisdiction to hear a motion for rehearing if their jurisdiction is strictly limited by statute? Does it include motions for rehearings?
Well, but the statute nor the rule prohibits the filing of a motion for rehearing. It simply says that if you believe that the general magistrate committed error, you can file exceptions and have it heard by a circuit judge. But
was your purpose in filing that for the magistrate to look at it again, or did you want the circuit judge at that point to look at what the magistrate had done? What was the purpose of you filing?
My purpose of filing the rehearing was twofold. Okay. One, it was absolutely clear that from Exhibit 45 that she had made a mistake when she said that the wife had only paid $2,000 of the MasterCard account. Exhibit 45 clearly shows it was $20,000. So in her equitable distribution scheme, she made an obvious, and I'm not saying it was intentional, but she made an obvious error in only crediting the wife with paying $2,000 instead of $20,000. And secondly, in her equitable distribution scheme, she said she gave the husband roughly $1.5 million and the wife $500,000. A $1 million discrepancy. And the case law says, and I refer to the case of Adams in our brief, that equitable distribution should be equal unless there are compelling circumstances to state otherwise. And in her original order, she assigned the following reasons for unequal distribution. The husband's age.
I guess my point is, when you filed that motion, were you seeking the magistrate to issue a new report to the circuit judge, or you wanted the circuit judge to look at what the magistrate...
I wanted the magistrate to correct her own obvious errors. I thought that, and I know that the case law says she has authority to do that, because she's acting in the capacity of the trial judge. She is sitting as a trial judge at that point. A trial judge can correct any interlocutory order upon review being sought if he thinks it's appropriate and change it. And I thought that the obvious error with regard to Exhibit 45, in addition to the error that there were not compelling circumstances to justify unequal distribution. The husband's age was 69, the wife was 67. She assigned the husband's health. The husband, based on the evidence in the record, had cancer in 2008, had been cancer-free since 2009, had no outstanding medical bills, zero, had Medicare coverage, and also he had been hospitalized 2 other times, once for a bowel obstruction, once for alcoholism, but nothing related to cancer. So there's no basis to saying his health was a reason for $1 million extra going to the husband. And his contribution to the acquisition of the coin collection, it was all with marital funds. Yes. He put the money in the suitcase and went to the coin show and brought the coins home. That was his only contribution to the acquisition. So in my mind, I thought that the court clearly made 2 obvious errors and should have the opportunity to correct those before I go to the expense of typing up a 4-day trial transcript and filing exceptions. And that's basically what happened.
It goes without saying that there's an unequal distribution. I mean, that's obviously clear there's an unequal distribution. Is there any part of the record that would support that, or that the magistrate looked at the statute regarding unequal distribution, which I mind, it's 61.075(1). Is there anything that would, from the magistrate's evidence he or she took in, would support that?
There wasn't anything in the record that would justify that. There was nothing in her written order. The only thing she says to justify the unequal distribution is what I've just recited to you. The husband's age, 69, the wife is 67. Health, cancer-free since 2009, covered by Medicare, no outstanding medical bills for his other hospitalizations, and his contribution to the acquisition of the coins, all of which was in marital funds. It was clear to me that there was no legal basis or facts to justify unequal distribution of 75% to the husband, 25% to the wife. And especially in the context that the husband had unclean hands. He obviously had taken all of these coins out of the house while he was getting all of these continuances of having the inventory made. And we found out, and shortly before trial, that the day before the final inventory was to be held, he rented a storage unit. He rented a storage unit at Uncle Bob's in Cocoa, and his explanation was, I wanted to put my son's Little League trophies in there. His son was 37 years old, and Dad still had them in the house, and he rents a 12-foot by 12-foot by 12-foot storage shed to put a cardboard box of trophies. That's why the judge said his testimony was totally unbelievable.
Obviously, the facts that you've laid out draw into question the motive of the husband, but you used the term unclean hands, which attaches, it's a very specific legal phrase or term. Did the magistrate ever use that specific term or find unclean hands, and was that finding on the record?
The words unclean hands are, but all of the language that would constitute unclean hands are set forth in her recommended report. I mean, they're there. I mean, the other thing is that even if by some stretch of the imagination you can justify, the unequal distribution. I mean, or given I think the magistrate thought that the husband has secreted these things and we're never going to file them anyway, I'm going to give them to him. Fine. The wife would have been happy with that. But then she went further and said, okay, I've only given the wife a little less than $500,000. Now I want her to take $80,000 of her retirement and give it to the husband. That is totally outrageous. I mean, there was absolute no justification for that under any circumstances, even if you could justify the unequal distribution of the coins and the value of $1.4 billion for the coins. So I would ask the court to reverse the ruling of the trial court and remand it for further proceedings.
Thank you very much.
Thank you.
Thank you, Your Honors.